4CRB now presents Legal Matters, proudly brought to you by Bell and Senior Lawyers. Call them today for all your legal needs on 07 55 32 8777. This program provides general legal information only. It's not personal legal advice. Everyone's situation is different, so please seek independent advice for your own circumstances.
Well, welcome to Legal Matters, and I'd like to welcome to the microphone in the studio Andrew Bell from Bell and Senior Lawyers. Good morning to you.
Good morning, Colin. Great to be back. Great to see some rainbows on the way to the studio this morning.
Bit of rain. Some people are loving it. Some people are saying enough. But, you know, it always seems to be that way on the Gold Coast, doesn't it?
It does.
All right, we've got a great program this morning. It is your program, which means that we'd love to hear from you. If you've got any legal question that you'd like to pose to Andrew Bell from Bell and Senior Lawyers, 0755 208888. I'd like to take a moment to recognise it is a brand new sponsor, not to be confused with the old sponsor of the program of about 2.5 years ago, and recognise that that is actually the case. And we'll dive into the program today. Last week we had a couple of callers who were talking about some political issues. One was the gondola to Mount Tambourine, and I think the other one was the beachside cafes. And you thought it might be a good opportunity for us to tackle the legal requirements or the law behind this style of complaint or concern.
Indeed I did, and this is a very different area of law that doesn't have a lot of overlap with the other things that we've covered recently. But it's called administrative law, and it's really a whole body of law that's been developed around decisions made by ministers and councils, not the legislation themselves, but when they're enacting decisions empowered by that legislation. And what can you do to challenge it, which is the major thing. And one of the things to know about administrative law is it's one of the most contested areas of law over the last 10 years. I was looking through the other day, and about half the High Court decisions have been on matters where ministers have made decisions around denying visas and other environmentally important decisions that have been challenged through court, and administrative law is the way to do that. So because it's developing a lot, I thought we might go through what is it and how can we challenge it today. But as Colin will point out, if you've got a call about anything, please give us a call.
0755 208888 is the number to do that. Well, let's start with the basics. What is it? Who can use it? And what can you actually achieve?
Well, yeah, so most people haven't even heard the term administrative law, or as I'll probably fall into, calling it admin law. It touches every single listener, however. Every time a government body, a council, a state department, a federal agency makes a decision that affects you, administrative law is the framework that governs how that decision must be made, and also what you can do if you've got it wrong. So if a unit block is approved, this will be done under an administrative scheme. If you're refused a liquor license, again, there will be requirements under the law around how that license should have been granted. If we go to the other things that we've had calls on, if they approve a cableway through a national park, all of these decisions are made inside an administrative law framework. And that framework governs the relationship between the government and the people that it governs.
Fantastic. All right, so if a council makes a decision that I think is wrong, administrative law lets me challenge it.
Yes. Now, there is an important caveat when it comes to administrative law, and it catches people out. It's not a mechanism for the court to remake the decision. It doesn't let the court say, we think this was the wrong decision. The challenge is on a legal basis, which is a technical thing, to say, was the decision made lawfully? So did the decision maker have the authority to make that decision? Did they follow the process that the law says they should have made? And the one big area that normally they get caught up on is, did they consider the right factors or ignore irrelevant factors when making that decision? Well, they also need to have made the decision in good faith. They can't have made it in bad faith or for an improper purpose. And those are the questions administrative law asks. If the answer to any of these is yes, as in they acted in bad faith, they didn't take the right things into account, they didn't actually have the authority to make that decision, then the decision can be potentially set aside. But and this is critical, a court or tribunal does not then step in and replace the decision. It's as if the decision was never made, which means the decision can be decided again. So hopefully then this is the correct decision.
Okay, 0755208888 is the number to call if you'd like a little bit of free legal advice this morning. Do not leave it to the end of the program. 20 minutes to go. We'd love to hear from you. We're continuing our discussion on administrative law, so you could win a challenge and still end up with the same outcome.
That's correct. So if, for example, hypothetically, the Minister for Immigration makes a decision and denies your mother a visa to come out and visit you, and you challenge it in court and say, well, they didn't take into account that she lived in Australia for 20 years or some other factor that they were supposed to take into account, it can go back to the Minister or the Minister's Department to make a decision. The problem is they could still turn around and say, well, this time we took that into account and we've decided that we're still going to deny her the visa. So administrative law can be very unfavourable. And this is one of the things that we're seeing with the Springbrook gondola, the cableway. So there's been 2 previous decisions made to knock it back based on other grounds, and they're trying to bring it back again. Now, you probably can never permanently stop these things, but you can delay them, or you can use that time to do other non-legal methods, not illegal, but not through the court methods to challenge the decision.
0755208888 is the number to call if you'd like to have your legal question answered live on air. Okay, what are the different types of review available to someone who wants to challenge a government decision?
Okay, so if you do start looking at the administrative law stuff because there's something you want to challenge, a school, a cabana, something similar, a quarry, you'll see 2 different lots of words. The first one is a merits review, and that's where the legislation has set it up so an independent body can look at the decision and make the decision again from scratch. This can happen, for example, in weapons licenses where QCAT can actually make the decision instead of the police on the same grounds that the police used. And that could create or substitute an entirely different outcome. If you're appealing a planning approval to the Planning and Environment Court, this is a merits review. The court can look at everything and actually grant you what you're refused or refuse what was approved. And the second is a judicial review, which is what we were talking about before, which is the most common form of review. This is purely about legality. So did the decision maker have the power? Did they follow the process? You're not asking for the court to agree with you. You're asking if the process was lawful. Ultimately, any judicial review will end up being appealable to the Supreme Court of Queensland.
Okay, 0755208888 is the number to ask a legal question of Andrew Bell from Bell and Senior Lawyers. Let's talk money now. How expensive are these pathways?
Okay, now this really again depends on what you're challenging and what's available in the legislation. And it's not a one-size-fits-all thing. So if you can do a merits review through the Planning and Environment Court or QCAT, you may be able to represent yourself. You can participate for smaller matters. You shouldn't necessarily require a lawyer, but you may be able to get legal representation. Judicial review, say you were taken to the Supreme Court, is an entirely different matter. You're talking about complex legal arguments. You're coming against very experienced senior counsel working for the government, lodging affidavits, and potentially weeks of hearing time. So that could easily cost in the hundreds of thousands, or if not millions of dollars. So these sorts of actions are normally only brought by interest groups who've had significant legal advice before they begin. And as I said, even if you win for the judicial review, you may just get the decision sent back for reconsideration, and they may make the decision again not in your favour.
All right, can anyone challenge a government decision, or do you need to be directly affected?
So previously we've talked about standing in other matters, and in this one there's no difference. So standing is the legal concept that you can sue. Not everyone can sue over everything. In common law, you normally need to show that you're potentially and specifically affected by a decision. However, say in Queensland's planning system, the rules are more generous. The Planning Act allows a person to make a submission on what's called an impact assessable development application during the public notification period. So you just need to be an affected member of the public. If there are things going through the Planning and Environment Court, similarly, you probably will have standing. Otherwise, you may need to form a local residents group or approach an environmental organisation. But lots of people can end up in court fighting these decisions, but only if they got the submission in the right period to be able to challenge the decision. You don't have forever to be able to challenge some of these administrative law decisions.
Okay. Well, this is your program. We'd love to hear from you. 0755 208888 is the number to call to have your question answered by Andrew Bell from Bell and Senior Lawyers. We're going to start now with Patricia. Good morning, Patricia. Ask a question of Andrew.
Yes, Andrew, I'd like to know, can you tell me how I start or who do I go to in the factor of I am 80, my sister is 82. 2 years ago, a woman came, contacted me saying I was never to have any contact with my sister ever again. I don't know where she is. She was taken from her house and put into care somewhere in Queensland. I'm in northern New South Wales. I was written this message was given to me by phone, and I wrote it down, stating that my sister didn't want me to contact her. My sister has frontal lobe dementia,
well, that's a massive concern, Patricia, and I'm sorry to hear about that. Legally, the way for them to, if you have been legally forbidden from contacting your sister, would be something through either called a peace and good behaviour order or through a domestic violence order. It's unlikely that that's what's happened here because you weren't served by police. But you could contact New South Wales Police and Queensland Police and ask them to check your record to see if there are any of those orders present. That would answer the question whether you're allowed to contact her or not. In terms of finding her, it's probably a bit more difficult. There are lots of different facilities that she could be put in, both public and private. If they're public, you may be able to contact the health department. They may say for privacy reasons that they can't find her. I don't know whether she'd still be on the electoral roll, but we work with private investigators who can often locate people quite quickly, particularly if they're not trying to hide. But legally, I'm not sure how you can find her. But if you check with the police, they should be able to tell you if there's an order prohibiting you from contacting your sister. But as I said, it sounds unlikely.
Right. Yes. Well, her estate would be worth close to $2.5 to $3 million. This woman sort of came out of the blue and just bam.
Well, sadly, you don't know if she's still alive. You may want to do a check for probate on New South Wales and Queensland websites to make sure that her estate hasn't already come into existence. But unfortunately, I can't probably help you much more than that, Patricia.
Right. Yeah, I've been getting coming against walls everywhere I go.
Patricia, it sounds very much like that you need to get some legal advice if you would like to resolve this issue. Does sound very fishy that someone who's not a family member has taken over this and made those statements. But that's up to you from here on in, and hopefully it's resolved and resolved in the positive for you.
Just one last question. Could I get it on legal aid, or would I have to pay for it?
You could contact legal aid and see if they have resources to help. You may also be missing persons or someone else to go through. And if this person isn't her legal carer and she's got dementia, you may be able to apply through QCAT to be her carer, because they normally favour family members over non-family members.
Right, yes, I was looking after her for several years, and then I couldn't do it any longer. She just got too much for me, so I put it in the hands of a nursing service. And, yeah.
All right.
So,
All right, Patricia, I think that's the end of the advice we can give you on the show, but best of luck with that one.
Thank you.
Good day. Thank you very much.
Thank you, Patricia. All right, moving on to John. John, ask your question of Andrew.
Morning, Andrew. Thank you for your valuable time.
Morning, John. How can I help?
I'm just inquiring. I have had a will made and an enduring power of attorney, which I've given to one of my daughters. I've also got a health directive.
Mm-hmm.
My question is, the firm that filled out my will, they hold a copy. Do they charge to hold that over a period of time?
I don't think they're allowed to charge you annual fees, but they may have charged you a fee when you drafted it to hold on to it. But it is technically your will, so you can request it from them at any time if you want to get it taken back or move somewhere else. They also need to be transparent in their fees. So if you call them, they should be able to tell you exactly if they are charging you to hold it.
All right, so it's possible that they could charge me.
If most of the time that they would have charged you a safekeeping fee at the time that you paid them to do the will.
Right, okay then. Thank you very much, Andrew.
No worries, John.
Good on you, John. Well, if you'd like to ask a question just like John, 0755 208888 is the number, and there is about 10 minutes left in the program, so you need to find that phone right now. Good morning to Rod. Rod, ask your question of Andrew.
Yeah, hi, Cole. Hi, Andrew.
Hi, Rod.
G'day. Just quickly, Andrew, we touched briefly on this about 3 weeks ago with regard to overhanging branches.
Mm-hmm.
I have overhanging branches into next door's property, which is a block of units. I've offered to share the cost of cutting them back and have no response from them. I am forecasting that what will happen is that you suggested that QCAT may send me a notice, I don't know what the term is, a notice to cut them down, and which is my total responsibility.
Mm-hmm.
Question, what happens if you can't afford it? If I can't afford it, what goes then?
If you can't afford to cut the branches on your own tree...
on the branches across the other side, I can't afford to do it. What happens then?
It's not something I commonly deal with. They can spend up to $300 without a court order to cut branches which you're liable for. Presumably they could then go through the courts and get an order for you to pay it, which may involve a bailiff or something else. It feels a lot, but it depends on the extent of the branches. But if you've offered to cut them and they're not accepting you on that offer, it doesn't sound like they're too keen for you to do anything about it anyway.
Well, no, I've offered. I know, I misled you then. I offered in conjunction with them to cut them back.
Mm-hmm.
And have never heard from them.
Mm.
Well, they don't have to be cut. It's at the election of the person who doesn't want your branches hanging over. If they're not prepared to enter into dialogue with you, it doesn't sound like it's a high priority. But presumably if there was a QCAT order, they then got them cut at their expense. At some point they may be able to come back at you for an order to get you to pay it forcibly.
Thank you sincerely. Okay, I'll just hang loose in the saddle.
I also put on the website some other notifications about trimming branches since you last called. If you want to look it up there might be some more advice.
Oh, well done and thanks. Well done. Thank you.
Good on you, Rod. All right. Yes. Look, it's that the shame of those sort of issues are that it's like anything else. Rates, water, those bills will come in. If you're responsible for your own property and your own trees, you're responsible.
And what we find is that people who own their own properties are often a target of people going aggressively, because eventually the ultimate remedy is to sell a property, no matter how unfair that sounds or how long someone's lived there. If people know there is actually assets, then they will go pretty hard to go and capture whatever money they believe is owed to them.
0755 208888 is the number to call if you'd like to have your question answered, just like Patricia, John and Rod. We've got 5 minutes left in the program. Please do not leave it any longer. 0755 20 8888. We've been talking administrative law, and it's been absolutely fascinating. We're going to continue the discussion. You mentioned impact accessible applications. What does that mean, and how does someone know if an application is one?
So town planning law is quite a complicated thing, and it evolves over time. So people may not be familiar with how properties and developments are approved, but in Queensland, development applications have different categories based on their impact. So there is a code, and every now and then that gets revised, and there is a Gold Coast one. Code accessible applications are assessed against the planning scheme rules. And if something is determined to be code accessible, as long as it ticks the boxes, it gets approved. The public has no rights or appeal rights for code accessible decisions. So every 10 years or so, and I know they're in the process of renegotiating one that's overdue at the moment for the Gold Coast, there's things to take into account like bushfire zones and other bits and pieces. But if you've got blocks of land that fit within, this is an area zoned for units or whatever else, as long as they tick the boxes, there's not a lot you can do about it. On the other hand, impact accessible applications are those with higher potential for environmental or community impacts. This is large developments in sensitive areas, things that require a more thorough public interest assessment, and they require public notification. Typically, this involves a sign going up on the land, and it will go through who is the developer, what is the scope of the development, where can you get more information, and when are the periods that you can put in a submission. It will also go on the council's development register. From the date of the notice, there's a minimum 15 business day window for public submissions, which isn't a lot of time. If you miss that window, your formal legal obligations are limited. So my practical advice is, if you're aware of a development in your area that concerns you, check the council's development register regularly so you can put in something and you don't miss out.
Absolutely. All right. Well, we might just go to a message from our sponsor, and we'll be back in just a moment's time.
Wills, probate, powers of attorney or property matters are legal issues that can feel overwhelming. Don't put off dealing with them. Call our trusted sponsors, Bell and Senior Lawyers. They explain everything in plain English and guide you through every step of the way. For caring, experienced advice, phone 07 55 32 8777 or head to bellsenior.com.au today. Bell and Senior Lawyers, making legal matters simple.
Well, we're back and we're talking administrative law. This is Legal Matters with Bell and Senior Lawyers. And let's talk a real-world example. Let's use the Springbrook Cableway. What are the approval hurdles that the project actually faces?
Okay, so this is a great example because it has to satisfy many different approval regimes, and it's already been knocked back twice, in 2000 and 2014, because it couldn't get through all of them. So if it comes back again, it still needs to get through everything. First, there are federal legislation, the Environmental Protection and Biodiversity Conservation Act. Springbrook is a national park, and it's part of the Gondwana Rainforest World Heritage Area. Any action will have a significant impact on that World Heritage property, so therefore it needs to go to the Federal Environment Minister. In 2025, a referral was lodged with the federal government with relation to works, and that minister needs to decide if it's what's called a controlled action, meaning it needs full federal assessment and approval. That process includes public consultation windows, which is where you can get in and anyone can participate. So we've ticked that box about standing. If the minister decides it is a controlled action and the proponent does not satisfy the federal assessment, as in they can't actually satisfy that they're protecting the nature and conservation area, it can't proceed regardless of what the council or state government want. If it does get through that hurdle, then there's a State Nature Conservation Act. National parks are protected under Queensland law. Cableway running through them would need a special lease or licence under the Nature Conservation Act. So the State Minister for the Environment needs to be satisfied that it's consistent with the park's management plan. The management plan for Springwood might need to be amended, and if it's amended, that requires public consultation. So again, you may have standing to get in and put your concerns there. Third, there's another area, native title and cultural heritage. So the Yungan people are the traditional owners of the Springbrook area. The council acknowledged in 2022 that traditional owner support was a precondition to proceeding. There's also been other native title holders who apparently are opposing the project. Under the Native Title Act, certain activities on land where native title has not been extinguished require either the consent of the native title holders or a formal negotiation process. If they don't consent, the statutory process is exhausted, which means that they can't continue. There may be other grounds as well around the actual details of the construction, how it's going to be operated, hours of use, and they may require multiple approvals through here. So this is a great example where there's multiple opportunities for community consultation, rules that need to be followed, and all of the boxes need to be ticked. Otherwise, they're going to have to go back to square one and start again.
Perfect, Andrew. That was a great example. Well, we're at the end of the show. I've probably got about a minute left for you to sum up, and it's been fantastic information.
Excellent. Well, so as we said, administrative law is challenging decisions made under legislation by ministers, departments and other groups. You need to look to see if you've got standing. You need to look at what the rules were for the decision, and you need to look at timeframes. And if you've got all of those, you can put in a complaint generally, which needs to be considered, and it may end up with the decision needing to be remade. Next week, we're going to talk about if you can't go through legal strategies. We'll look at political action. We'll cover the defamation again and parallel strategies to do with the law. And I'd also encourage you to go to the website for the show because I update extra information on there during the week, including last week about seats in restaurants and alternatives to try and getting around probate and estate trusts. So if you're really interested in what we're talking about, you might find more information there. You can go to the 4crb.com website to get a copy of the show. You can also go to the Bell and Senior Lawyers website. Andrew, I'm going to go to you for the web address. Yep, bellsenior.com.au. And both of those sites will lead you in one direction or another for more information. Great information, great show, Andrew. Thank you to the callers for calling in this morning, and we look forward to your company again next week at 9 on a Tuesday morning. Thank you, Carl.
You've been listening to Legal Matters, proudly brought to you by our trusted sponsor, Bell and Senior Lawyers. Call them today for all your legal needs on 07 55 32 8777. A copy of this and past programs and all relevant resources will be available for you to replay or download on bellsenior.com.au and 4crb.com.